Is your front door now a legal boundary or a negotiable line for federal agents? We're going to cover the shift in immigration enforcement. Immigration and custom enforcement, also known as ICE agents, are now entering homes without judicial warrants, using only administrative authority. No judge, no review. There is no independent oversight. If ICE can walk in without a warrant, what stops them from walking into your home? We're going to break down the memo, the law, the constitutional clash, and what it means for everyday American and the immigrant family. Keep in mind, this isn't just going to affect immigrants. As many of you might say, it's immigrants. No, this could very much be you. The everyday American, you can say Native American, you can say I'm born here, you can say I'm white, I'm black. It could be very much you. Your Fourth Amendment rights kind of mean nothing right now. Over recent months, credible reports and leaked intel memos have revealed a dramatic reinterpretation of enforcement authority within immigration enforcement, right? ICE. This shift centers around ICE agents utilizing administrative warrants such as Form I-205 to enter private homes in pursuit of individuals with final orders of removal. Traditionally, federal agents have relied on judicial warrants signed by a neutral judge to enter private residence absent consent, right? So, but now ICE leadership appears to be directing officers that a final order of removal coupled with an administrative warrant and a reasonable suspicion can be used to justify homes entry without any judicial warrants. This represents a structural reinterpretation of the longer standing practice, one that civil liberties attorneys have say that contradicts pretty much the constitutional rights, right, protection. So today, a judicial warrant is signed by a judge after law enforcement shows probable cause. This is also the gold standard under the Fourth Amendment, which I mentioned, which protects against unreasonable searches and seizures. Even immigrants have rights. So in the immigration context, even if someone has a final removal order, ICE has historically needed judicial warrant to enter the home, break down a door, arrest someone inside unless there is a constant or a clearly justified circumstance like imminent danger. Right now, with the administrative warrant, these are generated by the agency themselves. So ICE is generating these warrants themselves, not a court. They allow this basically allows ICE to detain or arrest someone lawfully, but not to force entry into private homes. So the long-standing legal norm has been you can arrest outside a home with the administrative warrant, but to enter the home at the point of leverage, you need a judge consent, a neutral judge at that. So that is how immigration law and the Fourth Amendment jurisprudence have been read for decades, hundreds of years, right? So in this month, this been revealed like back in May of last year, but it got, you can say, leaked to the public now, that internal memo has been circulating among enforcement staffs. While ICE has not publicly acknowledged it in detail, multiple outlet reports the memo instructs agents that administrative warrants may be sufficient to enter homes, providing notice and an opportunity to comply might justify forced entry. So use of necessary and reasonable force is authorized if access is denied. So this is a huge policy shift, okay? Not a statutory change. So what's different now? Before an agent could break into a home, right? Before agents could break into a home based on solely on administrative authority, now ICE leadership appear to be saying they can, based on internal direction, and move civil rights lawyers call a constitutional red flag. Now, at the heart of this conflict is the Fourth Amendment, the bedrock of American privacy and home security. It says, in part, The right of people can be secure in their persons, home, papers, and effect against unreasonable searches and seizures should not be violated. So this has been something that everyone has understood from this amendment. A home is the most protected space under U.S. law, right? To enter a home against a resident's wishes normally requires a judicial warrant. So even in immigration context where enforcement powers, are abroad, the law has recognized the privacy rights do not disappear at the front door. So there was a case back in 1976, United States versus Santana. The Supreme Court recognized that someone's home enjoys special protection. In Katz versus United States in 1967, the court emphasized the Fourth Amendment protects a person's reasonable expectation of privacy. So now ICE new practice potentially undermines this constitutional doctrine, right? And there's many other cases of legal precedents like Inns versus Rios Pineda. This is back in Ninth Circuit in 1989. This case held that an administrative warrant by itself does not authorize first entry without a judge's warrant. Yet the new ICE memo appears to contradict the legal understanding. Miranda Alvarez versus Clackamas County back in 2011, the Ninth Circuit said local authorities could not hold someone for ICE based solely on an administrative request. That decision underscored the administrative warrants have limits. So these precedents form the backbone of the Fourth Amendment protection. So ICE current guidance interpreted and applied may be placing the agency on a collision course with these well-established rulings for decades now. So in Minnesota, we have had reports in which that ICE agents are forcing entry into homes without presenting any judge's warrant, right? A U.S. citizen was reportedly pulled out of his home in sub-freezing weather without a judicial warrant. Families described similar tactics and not followed by a forcible entry using battering ram or physical force, all under an administrative warrant. So they knocked. I didn't open. They used force. So my brother had no warning. They came in with no judicial order. So these are not isolated antidotes. Like they reflect enforcement practices that are evidently tied to the internal memo that ICE has not, confirmed yet. And as you know, this is traumatizing families, children awakened by forced entry, U.S. citizens afraid in their own homes, and even more so for immigrant communities in fear of participating in any civic or public life. And these stories are now becoming part of the legal record in advocacy fighting. This is going to be 10 years from now, 20 years from now, 50 years from now. It's going to be in the history books. Our kids are going to be studying, our grandkids are going to be studying, and looking back, they're going to be like, wow, was there no one that was able to stand up and fight for justice to stop this administration from doing what they're doing to humans? So non-citizens and citizens alike are entitled to due process. This includes notice and meaningful opportunities to challenge the government's authority, which is difficult when the government bypasses judicial review. Right? So do not think this is just going to be affecting the Halimas or the Jose's or the immigrants. This is going to affect the everyday Americans. Okay, the next thing you know is maybe you have your savings under your bed. They're gonna come knock on your door because someone reported that you have money saved under your mattress, or you're a dealer or something. If you haven't subscribed, be sure to subscribe, like, comment, and share. This is truly, truly, groundbreaking information, news. You can say, stay informed, stay grounded, and I'll see you in the next update.